To as the accused. Mr. Malema, please be seated for the duration of the sentence. As judgment, the court can leave no stone unturned, so we'll arrive and I will tell you when to stand up. Thank you. Just as courtesy then, for the state appears Advocate Caesar and the defense being Advocate Odes and Advocate Nkukai Topi, as instructed by Ian Levitt attorneys. The others were mentioned and acknowledged on record yesterday. And as stated, the court will proceed with sentence. The accused before court was convicted of 5 counts. Count 1, contravening Section 3 of Act 60 of 2000 of the Firearms Control Act, read with the provisions of Section 1, 103, 117, 120, in brackets 1A and 121, read with column 1 of Schedule 4 of the said Act, being the unlawful possession of a firearm. Count 2, contravening Section 90 of the Firearms Control Act 60 of 2000, read with the same provisions mentioned in Count 1, being the unlawful possession of ammunition. Count 3, contravening Section 120, subsection 7 of the Firearm Controls Act 60 of 2000, being the unlawful discharge of a firearm in a built-up area. Count 4, contravening Section 120, subsection 3C of the Firearms Control Act 60 of 2000, being the unlawful failure to take reasonable precautions to avoid danger to a person or property in circumstances where it created a risk to the safety or property of the general public. Count 5, contravening Section 120, subsection 3B of the Firearms Control Act 60 of 2000, reckless endangerment to a person or property. The applicable penalty clauses as invoked by the state and in terms of Section 121 of the Firearms Control Act 60 of 2000, with specific reference to column 1 and Schedule 4 of the said Act. For record purposes, the court will place them on record. In respect of count 1, it is a maximum of 15 years imprisonment. In respect of count 2, a maximum of 15 years imprisonment. In respect of count 3, a maximum term of 5 years imprisonment. In respect of count 4, a maximum term of 5 years imprisonment. In respect of count 5, a maximum term of 5 years imprisonment. In essence, the various sections invoked by the state, as read with each count, means the following. I deem it necessary to state all this 103s. I will give a brief explanation. Section 103 of the Firearms Control Act 60 of 2000 deals with the crimes and offences giving rise to unfitness inquiries by courts after conviction or sentence of any of the offences as mentioned. Section 121 of the Firearms Control Act states that any person convicted of contravening any of the sections mentioned in column 1 of Schedule 4 may be sentenced to a fine or to imprisonment for a period not be exceeding the period mentioned in column 2 of the said schedule. Section 120 of Act 60 of 2000, as invoked in each count, refers to the offences, penalties, and the administrative fines applicable. Section 151 of the Firearms Control Act 60 of 2000 states that despite any law to the contrary, any magistrate's court has jurisdiction to impose any penalty provided for in terms of the said Act. The court deemed it fit to explain the relevant section invoked by the state in each count for clarity purposes only. It should be noted, and it is well known by this stage, that the provisions of Section 51, subsection 2 of the Criminal Law Amendment Act 105 of 1997 is not applicable in the matter before court, as the section was not invoked by the state in the charge sheet at the commencement of the trial. Therefore, the accused was not warned in terms of the above-mentioned section. It merely means that instead of a minimum sentence of 15 years applicable in respect of counts 1 and 2, the state invoked the penalty clauses contained in column 1 of Schedule 4 of the said Act, which prescribes a maximum penalty of 15 years imprisonment. I trust this explanation is understood and the reasons as to why the minimum sentence is not applicable and that the defense does not need to show compelling or substantial circumstances for the court to warrant a deviation of the minimum sentence legislation. Plainly stated is one of semantics, the one dealing with a minimum of 15 years, the second with a maximum term of 15 years imprisonment. With regards to the maximum sentence, the normal principles followed by courts when sentence is considered is therefore applicable. The above charges relate to the incident relating to the EFF, or the Economic Freedom Fighters' 5th birthday celebration held at Sisa Dukashe Stadium, Mdantsane, on the 28th of July 2018. The incident led to the arrest of the accused and his subsequent appearance in court on 27 November 2019. Thereafter, as a result of the COVID pandemic which the country faced, the accused appeared for the first time in person before this court, and you need to bear with me here, on the 29th of March 2021, on which date a trial date was then secured. The trial date for the matter to proceed was 27 August 2021. However, the erstwhile state advocate was ill, and she had notified parties beforehand that the matter may not proceed, and a postponement for trial was arranged in the absence of the accused and the defense team, and the trial date then secured being 28 February 2022. On the said date, Advocate Caesar appeared on behalf of the state, and the case formally proceeded, or the trial proceeded, on 1 March 2022 for the week up to the 4th of March 2022, being for 4 days. From there, it was postponed to 5 September 2022 for the week. However, and this is not criticism at all, because the matter was dealt with very professionally, as the defense had indicated a prior commitment and they could not honor the week of September. And in absence of all parties, his date was then arranged, being 30 January up to the 3rd of February 2022.
I'll show you. Okay, let's see, guys.
1 September 2020, following dates up to 14 September 2023, that was 4 days, and the state case was closed on the 14th of September, meaning it was a total of 13 court days that was spent on the state's case after hearing plus minus 19 state witnesses and 3 applications brought by the defense in that period. I would say 2 because the 174 I'll deal with now. As from the 14th of September, the matter was postponed to the 20th of September 2023, whereby a Section 174 application was brought by the defense, and the ruling by court on the 19th of October 2023 was then ruled in terms of Section 174, and that ended the state matter, the 3 applications, and it lasted a total of 15 court days. During the week of 18 June 2024 to 20 June 2024, after 3 consecutive days, the defense case was closed, and on 1 November 2024, the date was secured, including the date of 9 December 2024, was set aside for address on merits. However, due to myself having sustained an injury, I indicated to the state and the defense that there's a possibility that I may not be present on the 1st of November, which I happen to be, and they had elected, correctly so, the safest option was to proceed on the 9th of December 2024 for address on merits. Indeed, then it had proceeded on the 9th of December 2024, continued, where am I now? 2024. Thereafter, 29, yes, the defense case was then closed. It continued 29 September 2025, 30 September 2025, and 1 October 2025 for the extremely long judgment delivered by this court. I still shudder. Thereafter, it was postponed to 23 January 2026 for the pre-sentence report, which was then, the court heard the evidence of Ms. Jessie Thompson, and from that date postponed to yesterday, 15 April, and I will summarize the proceedings that took place yesterday, and then hence we find ourselves here today, 16 April 2026. In total, I think what felt like an extremely long time and which has been discussed as 7.5 years, it's clear having to combine 6-7 defense counsel state court was available, nonetheless was quite a task, and it amounted to the matter proceeding plus minus twice a year on 4.5 days per session. So the trial lasted, I would say, plus minus 31 days. Okay. Let's just see where I start. The court has decided to, in this instance, instead of starting by placing on record the provisions or principles traditionally taken into account by any sentencing court, to deal with the mitigating heads of argument placed on record by the defense, thereafter with the address by the state, and then the court will proceed in calmness with the principles applicable before sentence.
So just cut it
First
a little
then,
bit, then I'll
with
proceed because
regards
it's going
to
to be
the
too
heads
long.
of the defense and